On the syllabus really briefly because we want to make sure our speaker has enough time today. But as you know, it's a skill-based class where you'll be doing 13 drafting exercises, and it is mandatory that you do all 13 with the idea that 11 of the 13 need to be considered satisfactory to pass the class, and it's a pass-fail class. So just the format of the class on Mondays, generally, except for those constructed Mondays we have sprinkled in, the presenter will give a presentation on the topic that's indicated, and you will have already received through Twin, and hopefully you already did receive through Twin, the outline for the presenter's presentation, along with any sample documents or sample drafting exercise. And if you'll always be sure to read those in advance, that will help you follow along and get more out of the presentation. After today's presentation at 6 p.m., hopefully if it works right on Twin, you'll receive the drafting exercise and essentially have a week to accomplish that. I also put yesterday an assignment schedule on Twin so you could see when those were due. Once in a while they're not exactly a week, but most of the time they are. Tomorrow we'll have an opportunity via conference call to ask any questions that you might have about the drafting exercise to our presenter. So there's an expectation that you'll come with 1 or 2 questions for our presenter on Tuesdays during the conference call. Just a few things to point out. Again, we can do question and answer about the syllabus if you do have any questions tomorrow when we have a little bit more time. But keep in mind that next week there won't be a drafting exercise. Instead, we'll have 2 speakers, one talking about practicing law in South Dakota on Tuesday, and then Wednesday will be a 3-judge panel. And we ask that you come prepared with some questions for the judges. On February 16th, that class, again, that's a constructive Monday week, and the Tuesday class will be an extended class so that the presenter has their full time. So if you can make any arrangements for that, and if you have problems, let us know. You can contact Professor Ortiz. And then that Thursday will be a short class, so even though it's a constructive Monday, but just so we can follow our normal schedule of having a presenter first and the conference call second. So that's just a little bit about the syllabus. We can respond to questions tomorrow so we can get on with our presentation. Can you start it so I can introduce?
It's already started. So.
Oh, it's recording?
Yep.
Okay. So today we're fortunate to have Tom Welk as our presenter, and he's with Boyce Law Firm in Sioux Falls. Tom has practiced law for 38 years in the areas of civil, criminal, and administrative law. If you, at a later time, look to his website, you'll see a lot of really interesting cases and a lot of areas where he's really contributed to the legal profession in South Dakota by doing some great lawyering. So we're very fortunate to have him speaking here today. He is a graduate of USD 3 times, right? In economics.
That was slow.
Economics, MBA, and received his JD. Tom is board certified in civil trial practice. He is served as our past president of the state bar in 2004, 2005. He is also the founder of the USD Trial Academy and the co-creator of this course. And I'll let him tell you a little bit about how this course got started. So today he'll cover the topic of administrative law for us, and I'll turn the time over to Tom.
Thank you. Welcome. This course was designed to meet every law school's student's objection that you don't learn anything about the practice of law in law school. And it was designed about 15 years ago to be task-oriented. So when you complete this course, you will be able to actually do something in regard to the practice of law. How this course was formed was, as they go, a long time ago, myself and Tom Barnett, who's the executive director of the bar, Barry Vickery, and now deceased Professor John Hageman, sat down. And we sat down because of something was happening at the disciplinary board level at that time. And I was serving on the disciplinary board, and we saw a number of complaints against young lawyers, and especially young lawyers in solo or small firms. Now that's unique in the law because compared to your brothers and sisters in the medical profession, it takes a long time for you to screw up in law because it's not like you did an incorrect procedure or something like that. And so it was very troubling that we were seeing a number of complaints against young lawyers not being competent in what they were doing. And that was the essential task that we sought about to try to rectify. And at that time, the state of Wisconsin had a course that if you took it, you automatically passed the bar, and it was a practice and task-oriented course. What we did is literally sat down and did what I call the David Letterman top 10 things you ought to be able to do when you graduate from law school. And being all lawyers, we agreed on 8 and argued about 2, and created a list, and we, such as probate and estate, do an administrative law case, do a DUI case, do a civil case, do a divorce case, those types of things. And we started out, and it was a partnership with the bar and with the state bar organization, the law school, and we put together our best practitioners across the state, big firms, small firms, gender, geography. We tried to take all those in consideration. And then they started out with these drafting projects. And then what happened is I stepped away for several years, and the course developed a fatigue. It developed a fatigue because the instructors got tired of teaching. The law school wanted some more writing involved. It wasn't that much writing to begin with. And so it kind of had this fatigue, and about 3 to 4 years ago, I was asked to come back and refresh the course. And so we did. And we put the bench back together. I've told these instructors that you're going to see that I only wanted a 2-year commitment from them. And so you're going to see some of our best practitioners in the areas that are there. They've only committed to do 2 years, and we looked at the materials. Dean Huey and I and Barry Vickery sat down, and we created some new segments, some business operations, organizations. We sat down and even further refined what the task ought to be that you ought to learn. So you should have a very good background when you get out of here to practice law. Initially, this was thought to be taught for the lawyer who may go practice by herself or himself in a small town. I think it's changed. I would want any young lawyer in our course, in our law firm, to take it. I think regardless of where you go and what you learn, you're going to learn something practical. What is critical to this course is your own participation and independent participation. This is not a group course. The way you're going to learn is to do the project yourself. The evaluations of the faculty are critical. That's what we look at. We take those seriously. The materials, we want your evaluation of those, and we are constantly refining those and trying to make those better. In fact, there were a number of students that are now practicing lawyers who are listening to this course by audio. They found that they should have taken this course and didn't. So you're the smart ones. You're taking it now. And they heard about it, and whether it was because of comments or suggestions of other courses or what, years ago they didn't take it, and now they're back wanting to listen. So we have our brothers and sisters, newly graduates, that are listening. I will tell you that some of the sections you won't think are valuable. And I'm going to pick on one of them particularly. There's a section on attorney opinions. And you may not think that really makes any difference. But I'm going to tell you in 5 or 10 years, when someone asks me as an attorney to write an opinion about whether a corporation is in good standing, or to if you can act as a city attorney, and to do the opinion letter, it doesn't sound like it's a big deal. But the rest of us, we never knew what it was. We didn't know the obligations around an attorney opinion letter. So some of these things may not even look important to you. And even if you don't practice law, some of these issues are going to be very important to you as you just in your daily lives. So we're going to start out with that's the background of the course, and you're going to get as much out of this as you put into it. And if you do, I think you're going to feel that you're somewhat competent when you're done. We are not reading appellate decisions. There might be background on this, but this is a course that's intended to be practical and task-oriented. So let's start with today's lecture, and it's going to be on administrative law. Now, this course originally was taught sort of to teach workers' compensation, and that fell into a malaise, but it's because there's not a lot of people that do workers' compensation. In this state, there's about half a dozen to a dozen claimants lawyers and a half a dozen to a dozen employers/insurers. And I took this as a course that I spent a long time in this area when I was a young attorney general, and my interest was piqued in this when I was about 24, 25 years old, when I was doing white-collar crime prosecutions. And I was prosecuting, I found there was a pharmacist who had illegally taken some drugs, forged some prescriptions, and I didn't have much in my toolbox other than a misdemeanor conviction and potentially a felony, but it really wasn't that severe. And it was back then that I really got into administrative law because the Fifth Amendment doesn't apply. The licensing boards are what controls the professionals. And it was where I first got my interest. Never took an administrative law course in law school, so don't worry about that. But this is not confined to a particular agency. This is not confined to a particular discipline. It's going to teach you how to, if you were involved in an administrative agency case, this could be mostly at state, but it could be federal. You're not really going to talk about how to get in front of the city council because it's not covered by the Administrative Procedures Act. But we're going to talk about how to prepare a case, how to handle a contested case. I assume all of you have read 126 of the Administrative Procedures Act, how to do an appeal from the agency, and how to draft findings of fact and conclusions of law, which is going to be your project. I never drafted a set of findings or conclusions. No other law student ever did that I was aware of unless you had an internship. But it's something that's critical, at least in the litigation. The findings of fact are used in the criminal area, suppression areas, where you need to file, and they are critical in any sort of litigation practice to how to draft them. And it's an art how to do that. There's no book to go look at. There's a couple of guidelines, and only through practice and use and actually taking your own appeal and having to defend it do you learn how to become proficient in this. But we're going to try to teach you some guidelines and let you do that. Now let's turn to the resources of administrative law in this state. We have the statutes that are enacted by the legislature that are derived, and they also allow regulations to be promulgated by the agencies. So you have a set of, in every sort of discipline or licensing or that, there's a basic set of framework of statutes, and there's a set of regulations. There's usually a paragraph or a statute at the end of each substantive area that authorizes regulations to be promulgated. It's important that you look at that statute. It tells you what the agency can do as far as the broadness and what it cannot do. And so it's important to look at those. Any administrative law case, that's the first thing I do, is look at the applicable statutes and look at the regulations. There also is the South Dakota Register. That is similar to the Federal Register, where they publish proposed regulations. You can comment on it. These all used to be paper. It's all now in your digital world. It's there. It's very important. Also, very important is the State of South Dakota official website. There is a plethora of information that's out there on the individual agencies. I go to the Legislative Research Council, If you want to go and see statutes and regulations, the South Dakota Legislative Research Council is a nonpartisan agency and peer that works for the legislators to draft their bills. And they have a website. If you want to go and find out about a bill that starts the session tomorrow, that's the site to go to. You can do it by subject index. You can find legislators' identities in there. It's a gold mine. But on there, you can also find the regulations and the statutes. The other thing that has sort of got out of vogue, unless you're as old as I am, is to look at the actual session laws. When the legislature passes laws in this state, they pass bills, and then they're put in the code book. And so the session laws are the organic document that is what breeds the statute. And when you really get into this area, oftentimes, that's sort of a lost art today in law school, in my view, is to get back to the session laws and to find the backbone of the statute. You'll be surprised how they came in, how they were amended, and it's always a good thing to try to go back on the key things. The agency declaratory rulings, these are where you go to an administrative agency and ask them to declare what the meaning of a particular statute is that they administer. Those are found also in the administrative rules. You'll see them as almost footnotes of declaratory rulings. They're binding on the agency usually, although some new Secretary of Revenue may say that he or she may not be, but they're very good in the federal arena and other states. I'm not sure how much they rely upon them. You see them in the IRS with revenue rulings and things like this, but it's key around here, and we're developing a few more of those. The South Dakota Attorney General opinion, and not a lot of people understand the significance of that, so I want to tell you what it is. I worked in the AG's office for 4 years, and I was the chief deputy when I left. I had the litigation side of the house. The government side of the house was another chief deputy. County commissioners, legislators can ask the South Dakota Attorney General to give them an opinion on the application of a statute. When the Attorney General gives that ruling to that legislator, county commissioner, it's binding on that person. So if a county commission says, I don't know how to administer this tax statute, Mr. Attorney General, tell me what it means. That county commission would be then necessarily bound by it. But private parties cannot seek the Attorney General's advice. As far as the courts are concerned, it's nice to look at, but it's not binding. So I use them if it's something that supports my position. I might cite it to a court knowing it's not there. If it's something that's against me in my position, it's not binding either. So that's the significance. You'll find those on their website. The questioner posits a set of factual questions, and then the Attorney General will answer. And if you look down there, normally it's the Attorney General signs everyone, but normally if you look in the lower left-hand corner, there's some initials. That's who actually wrote it. It was the assistant who did it. And it's important to know those, and especially if you're involved with county commissions or legislators, it's an important place. So that's the last thing I already talked about is the Legislative Research Council. This is your menu of where you go look, okay, for what you might be involved in any administrative case involving any other, or a case that you have, a contested case to start with. All right, we're going to go then. We're going to take a hypothetical, sort of as I walk through this, and I'm going to take a licensing board. And if you've read the Administrative Procedures Act, there are certain types of agencies that are not covered by the Administrative Procedures Act. Lawyers are not, for example. But doctors and accountants and just about any other profession, there's a licensing agency. So let's take a doctor or a dentist who comes into your office and has got a complaint that's been issued by his or her licensing board. And so when the person comes in, here are some of the questions that I'm looking at, and I'm helping to try to find out what my strategy is going to be in representing this particular profession. First of all, who is the executive director of the agency? Now the agency itself might be part-time. I mean, let's take the medical board or the dental board. Who sits on that board is in a statute that tells you who's there. And then there's an executive director who is responsible for the paperwork. They usually don't vote on the board, but that person is the conduit who knows the agency people and knows their history normally. So it's a very important person because they control the paperwork and they can help you find out a lot of things. If your person is just someone that's the first time in front of them, you can also find out if your person has been in before. You'll find out the reaction on a phone call, not an email, a phone call, okay? One of the things I want to dispel from your generation is the emails in some of these. The phone calls work the best, all right? And I know that's not part of your DNA in your world anymore, but this is where you find out the information. You pick up the phone and introduce yourself to the executive director, ask a bunch of questions about the board. Some of them you'll look in the statutes and regulations, but just find out from the executive agency what they think about your person. You know, what's the nature of this complaint? Is it a big deal? I mean, if your complaint says we're going to take your license, you know this is a serious matter. If it's a minor thing where it could be fine or not, you can find out about what the histories might have been of the fines, and they're just a wealth of information. Who are the members on the board or commission? First, another thing that you've got to find out. Most of these boards have people from the profession, and they usually have a layperson involved. And you need to find out who these are, because the person that you're representing might be a competitor, might have had a problem with them, and you need to know that. And it may take a few phone calls. Nobody's going to tell you this in an email, but you're going to need to find out about the board, what their past history is, what they've done on these complaints. You cannot contact the board members. That's a violation of 126, because when you got the complaint that created this bar, they're in a quasi-judicial capacity. You can't talk to them. But you can talk to former board members, or you can talk to former counsel. You want to find out also from your client, what's been the contact with the agency, they had prior complaints, and also the contact with the board. So they have something that's going on with a member of the board, and we'll talk a little bit about what you might do. You want to find out who the lawyer is for the agency. And the AG's office advises a lot of boards, but some boards have their own lawyers that are private. And you want to find out who that person is. Now, that person is going to provide legal advice to the board, or they also may have a second lawyer, which would be the lawyer that would be presenting the complaint against your client. So you want to find out there's two lawyers that might be involved. One who's basically giving the legal advice to the administrative agency, and the one who's presenting it. Now, the person who's presenting it may have signed the complaint, may not. You need to find out. And ask your client for all communications your client has received and sent to the agency. And I always ask the agency to get a duplicate copy, because you would be surprised. Sometimes they don't keep it, and sometimes they don't give you everything. So you're going to want to, as part of your preparation to get it from the agency's file, but you're going to start with your own client. And please, any questions, stop me along the way. I'm going to be going quickly here, because it takes a while to get through the process here, but if you have questions, just please raise your hands. Okay, so we're talking to our client. And then our next step, okay, we've got a copy of the complaint, we know the agency, we've done our research, we know our substantive law, we've looked at the regulations, and then you start to investigate the facts. You try to find out, what happened. Are there other agency actions similar to you? You're researching in the law pertinent to your case. You're investigating the background of the board members. You're trying to find, you don't do that overtly, you do it subtly by contacting other people, maybe other lawyers who have been in front of this board. Determine who will be presenting the case against you, your client, and advising. That's the two lawyers that I was talking about. All of this stuff you need to find, because these are all people issues that you're going to have to find out to adequately represent your client. You don't just show up on the date of the hearing with your client to defend your case. You are not competently representing your client. You need to find out all of this background, because you're going to have to competently advise who your client is, or what the courses of action. All right, let's go to the next one, the analysis. This is what I call the most critical phase, and what a lot of lawyers miss is they just want to show up at the hearing and present their case. You really need to get in at this point when you've done your research, you've kind of found out background. Do I have a fact issue or a law issue, or is it mixed in front of this agency? And by that I mean, if it's a fact issue, is it a matter of who said what? Is the agency regarding your licensee going to have to believe one witness or another? Is there an issue about what happened? Is there an issue about the law of whether your client, if the client has done what they've alleged to have done, does it violate a statute, or is it a mixture of both? And why this is important is because when we get to the scope of review and we get to the appeal, knowing this right away is very important because it will provide the advice and the strategy you will be representing. Many people don't stop to do this, but if you do this correctly, you will be better positioned to advise your client, including all the way up to the Supreme Court. If you've done the analysis at this point and realizing in every case you have, the facts may change. And I'll tell you one thing, one of my mentors told me years ago, the story never gets any better than the first time your client tells you. Let me say that again. The story never gets any better than the first time the client tells you. So they don't always tell you the truth. But your job is to assume that they're truthful and then look for the facts to see if they are truthful. And especially in an administrative agency, this is not a jury of people that don't know the profession. Most of these boards are composed of people, dentists, doctors, accountants, that are good where they're at and what they're doing. And they're normally, people don't get on those boards that have licensing problems. So it's very important to try to find out the facts. If you don't know some of the issues, if it's an accounting issue, an engineering issue, a surveying issue, then you've got to get yourself educated. All right, another thing on the analysis of the issues, and we're going to talk about this, and that's to determine the burden of proof in the contested case. And if you'll see in the outline, the general burden of proof is preponderance of the evidence. And the way we explain this in the real world to juries is that oftentimes the scales of justice is used and preponderance is 51% and you carry the burden of proof. And we know from criminal law that the highest burden of proof is proof beyond a reasonable doubt. There's also a burden of proof called clear and convincing. It's between the two. And in certain licensing cases, and we're going to talk about that, is that because your professional license is a license that you earned, if the license is revoked, there's a clear and convincing evidence standard. And if you look in the outline, one of the things that let me go to the next one, the licensing cases. Here are the clear and convincing standard is required for the revocation, but not the granting of the license. The second case, the Jarman case, just came down. And they held in that case for the first time that in regard to receiving your license, it's only a preponderance of the evidence. In that Jarman case, it was about a law enforcement officer who's licensed by a licensing board, the Law Enforcement Standards Commission, and he, because of an abuse situation between a girlfriend, did not get his license. And so the issue, among other things, was what's the burden of proof? And they clarified. So if it's revoking, it's clear and convincing. If it's granting, it's preponderance. Another thing to look at is this tort standard. One of those cases is mine up there, Dr. Nelson's case. And he was a dentist. And he was charged with administering anesthesia by not supervising it for one of his assistants. Very interesting. I got my teeth cleaned today. I never saw a dentist. But anyway, there's a statute that says that the dentist is supposed to directly supervise the dental assistant. And he was a pediatric dentist, and he was not well liked by some of the members of the dental community. And we had an agency decision, or had an agency contested case. I brought in an anesthesiologist who said that whatever he was doing, he had like 6 chairs and he could see them in different rooms, that there was nothing wrong, and the quantities and all that stuff. But in that case, there was a regulation that said this is how it should be administered. And the court said if you have a regulation that sets a standard, then it's not a tort standard. Now juxtapose that against the Schramm case, which is another dentist case, He was accused of acting unprofessionally as a dentist, but there wasn't a regulation regarding his. It was a competency issue, a straight-out negligent. They brought in experts. So they were able to bring in an expert and says Dr. Schramm was acting competently. Nelson, I did the same thing, except they said, oh, nice try, Mr. Welch, but there was a standard in the regulation, and all the agency had to do was to look and see if the dentist violated that, and that was sufficient for the dentist to be disciplined. All right, the other thing is to review the statutory authority for the unlawful delegation issue. Now what that is, remember I told you there's a statute normally at the end of every section, of substantive section of an agency, and tells you what the agency is supposed to do as far as promoting or promulgating regulations. You would believe it or not, sometimes agencies go beyond what they're authorized to do. And you should always look at the regulation that's at issue to see if you have an argument that the agency went beyond what the legislature authorized. Because the agency itself has no power other than what the legislature delegated to them. So this is the unlawful delegation. Always put this on your checklist to go look at. The other thing that I normally do is to look at other cases that have been done in front of the agency by settlement or by consent order. Now you probably, anybody heard the term consent order? Anybody know what it means? Nobody? Okay. Well, consent order, you see it, the SEC cases, you sometimes see them with the Justice Department. It's both civil and mostly where you have a situation where there is a criminal case, or it might even be a civil case. The SEC does this often in broker-dealer cases and others, where they come in and they say, look, we admit we did no wrong, but we agree to pay a fine and do this. And that's a consent. And oftentimes I've used that to try to negotiate a settlement where your licensed person does not have to admit, but they might pay a fine, they might have to go do some training, they might have to take some courses, but it's a way to not have to go through the hearing and get something on your record, but it's somebody you're going to have to negotiate with. And who are you going to negotiate it with? You're going to negotiate it with the lawyer who's going to present the case, not the lawyer who's advising the commission or the agency involved. That's why it's important to know that. Have they done consent orders? For example, in this state, securities, insurance agents, it's a typical deal. If somebody was supposed to give this much material to an insured, to let them look at certain things, and they didn't, and it's a case in which there have been many complaints, you'll see consent orders, there'll be consent orders and fines, and then they'll move on. Okay, next slide. Now the preponderance evidence, these are the ones that I'll give you some background. That's the general preponderance of the evidence for licensing cases. So that's your general burden of proof. If the agency says you violated this, unless they're going to revoke it, it's going to be a preponderance of the evidence, which is not much. All right, next slide. All right, the scope of review. This is probably one of the most important things to understand from the legal analysis. And this is what I look at remember when I talked about knowing whether it's a fact, whether it was law, or it's mixed. 12636 tells you what the scope of review is from the administrative agency to the circuit court. In South Dakota, we have the Supreme Court, 5 justices, and we have the circuit courts, where there's 37 or 38, depending on the geography around the state. The agency's decision is appealed to the circuit court. And so, first of all, my question is on what is going to be the scope of review. On the findings of fact, it's going to be a clearly erroneous. In other words, did the agency make a mistake? Doesn't mean that someone else couldn't have made a different decision. And on the conclusions of law, it's de novo. That means it's like new. There's no deference given to the agency. So now we go back to why did I say that looking at the scope of review is important. If you have a pure legal question, you know that the agency is not going to get any deference. Now, I need to do a quick footnote from the federal administrative law, because the federal administrative law is different. There's a major U.S. Supreme Court called Chevron. It's called Chevron deference. I mean, it's the principle is the deference. Under the federal agencies, if they regularly administer the statutes, the federal courts defer to the agencies unless it's contrary to their authority on ways they administer the statute. We don't have that in South Dakota. So anytime that you're dealing with a conclusion of law, it's a de novo review, which means that the circuit court is going to look at it anew and the Supreme Court is going to look at it anew, because there's no deference given to the circuit court on a de novo standard of review. So it's extremely important to figure that out. Now some other scope of review issues, and these are substantial evidence. Used to be one that was out there, but it's basically the court looks to see if it's definitely and firmly convinced a mistake has been made. That's the standard. Sometimes there's a record that's completely documentary. By that I mean, for example, a lot of the tax cases I do, we stipulate all the facts. This is what you owe for tax, this is what you say it's worth, this is what we did. Most of the time there's not a dispute as to what happened. And if you are able to create a documentary record, it's a de novo review. So that's good for you for the licensing, because the agency is not going to get a deference if it's a documentary review. All right, another thing that you need to look at, this gets to be at a hyper-technical level, but I want to at least bring it up to you. When you look at someone, you look at a complaint, and they allege that something happened, they allege that it violated a statute. That's what they do, or a regulation, or both. And when you're looking at whether the statutory requirements are met under the review, it's a clearly erroneous standard when the inquiry is essentially factual. So that means that the agency gets a deference. It's another one in my case, is another loss. I didn't lose them all, but this one is another one. This is a banking case where a trust company in Sioux Falls was trying to stop Dorsey Whitney, a large law firm, who opened up its own trust company and for its own clients. And one of the standards was that the existing trust companies were not adequately serving the areas before you get a new. And Dorsey Witness was, we're not coming into your area, we're serving our own client. And pausing for a moment the ethical considerations of the double fiduciary duty of a lawyer and a trustee, which is beyond this course, the court said, well, it's a close call, but those people, it was the agency in about a 3-2 decision said, well, they're not being served because they're clients of a law firm in Minneapolis, so therefore I guess you can have your license. That's why it's important to know what are the statutory standards, and you have to meet those factually. So that's the inquiry under Dorsey Whitney. That's important. Okay, next. Okay, the abuse of discretion. You see this in civil cases all the time, evidentiary rulings and all that, but it's the same standard here. Do they have the authority? Did the agency have an authority to make the decision? And did the court, and whether the court believes a judicial mind could reasonably have reached the conclusion? They don't have to say that they would have reached the same conclusion, but it's this abuse of discretion. Is it something under the circumstances that was reasonable under the circumstances? Now this is very important, because when you're going to look, representing your licensee, when you look at the statute and you look at the facts that you have, is it going to be an abuse of discretion for the agency to make this decision? If it is an abuse of discretion, if you lose at the standard in front of the agency, you're going to have a very difficult time on appeal. So it's important to know what that standard is going to be in your case. So we've kind of laid all of these out. We've now decided, okay, now we've taken the time to prepare it, and how do we prepare ourselves for an appeal to the circuit court? Now, in this instance, we're going to assume that we've gone to the agency, that we've had a hearing, and that the decision is adverse. And so we're going to be looking at what we're going to do to appeal to the circuit court. First of all, clients always want to know about costs and fees and what's it going to be, and also what the time delay is. I tell clients that the circuit court appeal is normally somewhere between 90 days and 6 months. Why is that? Well, first of all, you have to have a transcript of the hearing. We'll talk about that later, about the actual hearing. But it's going to take a period of time to prepare the transcript. Then the briefs are going to be at the circuit court level. Those are normally 30, 15, but normally we negotiate with the lawyers. Then it depends on how long the judge, if the judge wants to hear an oral argument or whether there's a written decision. Generally, 90 days would be extremely quick. 6 months is normal. And then from the decision to from the circuit court to the Supreme Court, I usually tell them it's a year. And the reason that is, it's 45, 15 for briefing. There's a transcript of an oral argument. And then it depends on when the queue is set up on the briefing. If you don't get your briefs in to allow it to be argued by May, and the court always needs about 30 days notice of oral argument. So when you see these in the court come down here, there was a letter that came out that said 30 days before the argument, this will be the date of your argument, unless you're dead, you will have it on this day. And so then the court has an internal rule. They like to get it done in from about 90 days to 6 months. So within that year, it's a pretty good, now sometimes they do it faster, depending on the issue, but those are sort of the issues I talk with clients. I also talk with clients about a stay. That means trying to stop their decision, assuming you had an adverse decision. The stay request must be made within 10 days of the receipt of the decision. It's a very quick time. And there are 4 factors. It's similar to an injunction factor. They're basically probably a success, public interest. You keep going on that, flip it over. There are those 4 standards that are there. So that's if you go and get the stay. I've not done those except in really large utility cases where rates go into effect and millions of dollars are there. But if you're representing a licensee who's trying to support a family and their license is taken away, you better know that you could get a stay. Because then you're going to come in and they're going to have to prove, like an injunction, a probability of success on the merits, the public interest, and those type of things. You remember the doctor that you might have seen down in Sioux Falls? Or she was convicted of the election violation, and then she did an appeal, and there was a stay issue about whether she got to keep her license or not. That's the stay issue that are very important to professional people. Yes?
Would it be an okay place to take a 10-minute break?
Sure.
I forgot to mention that at the beginning of class, but normally I think we'll have a break.
Anybody have any questions so far? I'm going this at rather quick speed, but hopefully you're getting it in. Okay, so we'll take a break. Good. Are we back online?
Yes.
All right, we're going to pick up with the contested case hearing itself. We've been kind of talking around it, analyzing what we're going to do, even talking about an appeal. But let's talk about the hearing itself. And the way that it manifests is your client came in with a notice of hearing. And under the Administrative Procedures Act, there's certain things that have to be in the notice of hearing. And that has to be, you have a right to counsel, where the hearing is going to be held. Normally it's not 10 days is the minimum amount, but normally they're set whenever these administrative agencies sit. And they normally sit about once a quarter, sometimes a couple times a year. If it's a serious matter, they'll have their own. But you'll get the notice of hearing. So you've done everything that I've asked you to do to analyze it, but we're going to get you prepared for the hearing itself, actually how to prepare it. Remember, one of the questions I ask is to find out about the decision makers that are on the board, whether what their background was to your particular client. And this case here, there's 2 of them there. One of them, that Stoffern case is mine again. It dealt with a PUC commissioner that was sitting on some Northwestern Bell cases when we deregulated the telephone industry. And this particular commissioner, who is elected, by the way, and is a constitutional officer, made a number of sayings in the legislature, like the phone company is wolf in sheep's clothing, and was very derogatory. So I was confronted in representing the company with someone who was not a lawyer, who was going to be sitting on a very monumental case to set really basically deregulation in South Dakota. So this case, we had to file an action to remove him. And this case has to deal with what is the standard for removing someone on the agency. And there are two different standards. There's a standard dealing with the administrative case or the contested case where they sit in a quasi-judicial standard. And there is also a different standard if they're sitting on, as the agency promulgates rules, because the way you promulgate rules, there's proposed rules, public comment, and then the agency adopts rules that sometimes are very difficult for certain industries or licensees. So there's a different standard. One is the unalterably closed mind, and the other one is more as closer was Tobias on Stoffern. And the Supreme Court ended up in that case saying that Stoffern couldn't sit. He was a very nice guy. I used to have to go into hearings because the phone company was regulated, and we'd talk, and I took his deposition, and it was not comfortable, but it's what I had to do. Now, why am I bringing this up? Because if your client tells you that there's a bias on one of those people, that's my competitor, my ex-girlfriend is sitting, she's now a dentist sitting on the board, and you hear these things, or you find out from other people, if you follow what I suggested to do, that people are not going to be favorable. Maybe it's a particular issue that one dentist or doctor you know through your discussions is not going to sit there. So this is a very difficult decision because you heard the saying, if you shoot the king, kill him. If you don't get him off, you've just lost one vote. And because most of these agencies are lay people, they're not lawyers, they don't understand it's not personal, okay? So this is a very big decision whether to try to kick the decision maker off. And you better be right. It was easy in Stoffern, he'd made these really stupid sayings, and they were public, and we had lots of witnesses, and he had testified in front of a legislative committee, and we had a lot of evidence. But a lot of times you don't. It's what somebody might have told you, so you must weigh this very carefully. You cannot do it while the hearing, you're going to have to do it before, so it's something you weigh very carefully. And you have to, and strategically, you have to explain it to the lay people why you're doing it, that you cannot waive it, and so it's a big deal to make this decision. Oftentimes, just because somebody doesn't like them or they got mad in law school or dental school or whatever it is, isn't enough to get them off. So it's a judicial standard. Weigh it carefully, but you'll waive it if you show up in front of the hearing and don't try to kick them off. But it's there. All right, your project is going to be to draft findings of fact, conclusions of law at the end for a hypothetical, a realtors who you're going to represent. I found this out after about 10 years in practice of doing this, that I draft a set of findings and conclusions before the hearing. Now that seems counterintuitive because they're presented to the decision maker afterward, but it becomes a checklist and it is invaluable. What it does, first of all, it forces you to think through all the issues we've talked about the burden of proof, about the scope of review. It forces you to that. It also forces you to think through what is really important in your case. And even when I've tried divorce cases or court cases to the court, it's a very useful thing to do. Now, you're normally trying to get witnesses, trying to prepare examinations, and you think, I just don't have one more thing I can do. But it's probably one of the most valuable things you can do. It even helps with the witness preparation because what it does, it focuses you on what is really important in the hearing. And if an issue is not important, then you really don't care about it. But if you sat through this and drafted these, at least a preliminary draft, you don't send them to the agency. You keep them on your file, electronic file, in your notebook, whatever it is, electronic or paper, and use it as a checklist. All right, discovery. There's particular agencies, each have their own rules. However, the rules of civil procedure apply to contested case hearings. And contested case, I should have talked about that. That's defined under 126. It involves essentially any license approval by a state agency or any other agency that can be defined by 126. So you can take depositions. We often do. They're expensive, but you can take them. You've got subpoena power that you can subpoena. You've got broad tools. Most of the time, you don't have the money or the time to go out and take depositions. But oftentimes, they're good. I also like issue a subpoena to the executive director to get the file. You can cut a subpoena and say, I want to see the file. You have the authority under the Administrative Procedures Act of the agency to get the file. Get the file. Make sure what your client gave you was accurate. So, and sometimes they'll just copy and send to it. Get the file. And if you're around the agency, go look at the file. For the little notes that are there or not there, you would be surprised in the civil world how many times somebody wrote a note or the executive director wrote a little sticky note that might be in the file that may not be in an email. All right, the Office of Administrative Hearings. It used to be, and there's a federal office, the federal system had this a long time ago, but in South Dakota we did not have a separate Office of Administrative Hearings. Several years ago it used to be that you'd go in front of the Department of Revenue and they would have a Department of Revenue lawyer that would be presenting the case and a Department of Revenue lawyer advising the Secretary on the decision. And it was like you had no chance. All right, the Revenue Department was going to win. I always say, and as far as the tax thing, that revenue people wake up in the morning thinking your firstborn is taxable and you need to find an exemption. You're going to lose most of the time in front of the Revenue Department. But several years ago, the Office of Administrative Hearing Officers was created. They're a group of lawyers they are paid by the state, but they're not beholden to any agency. Used to be 4, I think now there's 2, there's somebody retiring. But they sit as semi-judges in these contested case hearings. There are some matters, revenue for example, and that allows them to be involved in the case. I think it's $2,500 or something, depending on the amount of issue. But it's a separate office that has jurisdiction over certain contested cases, and it's also something you may want to ask for if you meet the threshold to get someone to hear the facts of the case. Another question I always want to know in going into a contested case, who's making the evidentiary rulings? Remember I told you there's normally a lawyer presenting the claim against your client, and there's one advising. Now, most of these agencies are not law trained, and so they have a lawyer. And the way the hearing is normally conducted is the lawyer conducts the hearing. And the lawyer comes in and says, the agency, we're here on the licensing of the medical board on Dr. Smith, and they'll read some standard thing, and here are all the people, and I'll make the initial rulings on the evidence, but then the chair will, it can overrule me. That's normally what they say. And so it's very important who that lawyer is, because knowing who he or she is and what their proclivities are and whether they have any experience in this area or experience with the rules of evidence is very important. The next one. All right, this is a strategy that's somewhat subtle, but very important. Determine what your strategy is going to be for the appeal. And you need, as a lawyer, to look at both what can happen from a positive standpoint and what a negative standpoint. And if you've looked at it and said, well, I've got a de novo review. This is clearly a statutory interpretation. The facts really don't make that much difference in this. Then you maybe not care as much about the evidence if it's a de novo review. However, if you have to make objections, and remember this is mostly are lay people, and there's evidence in these administrative hearings that comes in that is different than in the rules of evidence. Even though it says it's there is another provision that says that any competent evidence or a reasonably prudent person could rely on could be admissible. I used to say in the PUC, I think I could mark the kitchen sink and get it in. And I mean, it's very loose, all right? I mean, they don't do a lot of articles and hearsay and stuff like that, but some of these sophisticated agency people have been trained, they've gone to agencies and go, well, we'll let it in and we'll give it the credibility we think it's worth. So you really need to decide what you're going to object on. And if it's something that's really important, you want to make a record on it, you better think about ahead of time how you're going to preserve it. And one of the things that, especially dealing with lay people and not lawyers, they all think we're obstructionists, all right? And so you have to deal with that issue above. And the way that I've dealt with that is to say that the lay people is, look, I've got a client to represent. I'm going to be making some objections. I'm not trying to let you deprive you of what you ought to see deciding this case. But if I don't make these objections, I waive these objections from the protection of my client. If you will deal with it up front, rather than just looking to a lay person that you're an obstructionist, you'll be okay. They'll be able to process that. But if you're going to make objections, you're going to have to think about that ahead of time, about what your strategy is going to be. The next thing is don't leave anything for after the hearing except late file exhibits. The appeal is on a record. There is no witness that's called in the circuit court or the Supreme Court for the appeal. It's the record. It's the transcript. You don't get another second bite. This contested case hearing is it. Now, what do I mean by late filed exhibits? Sometimes when a lot of these, we don't have the advantage of doing some of these commercial cases and other things where we spend tens and sometimes hundreds of thousands of dollars in discovery. These are normally a licensee. Maybe if you're lucky, you might have taken a deposition or not, but you're doing a lot of this on the fly. All right, so you don't get to prepare maybe as much as you can or like to for time, for money, for a lot of reasons. Sometimes there's something that comes up in the hearing that somebody says, well, I have that email at home. I testified about this and that, and I have that email at home. And they'll say, all right, we want to see it. Well, what you do as far as the hearing is say, I'd like to reserve an exhibit number. Let's say your hearing was done at exhibit 50. I'd like to reserve exhibit 51 for the late filed exhibit. Now, it's not something you can just throw in, for the heck of it after you thought about it in the car on the way home. It's something that came up in the hearing that you want to get into the record, and that's the best way to do it, is reserve a number for a late filed exhibit. Another issue to think about on the contested case hearing is whether you give opening or closing statements. And it's like a trial. I would tell you never waive an opening statement. And why? Because, first of all, let me put you in the context of a lot of these administrative agencies. They have these meetings, as I suggested, maybe once a quarter, maybe a couple times a year. They've got a lot of other things normally other than your contested case hearing. They may have multiple contested case hearings. They may have lots of things they're doing. And they're lay people, they're getting paid very little, maybe their mileage, maybe $50 to come to this, and they're out of their office losing money working on this. And so the opening I never waive because it's your opportunity to tell your case. All right? Even though it's going to be, I just have never done it, and you need to spend more time on your opening than your closing. Because you need to give them a roadmap of what you're going to do. And this is where you can tell them, I'm going to object, or I'm going to do this. This is what I'm going to prove. And one of the things that I've done in a lot of the hearings, if you're going to have a number of exhibits, you can't give them to them ahead of time. But I normally, now with the digital world, it's a little bit different, but I used to do notebooks for every member. And if I had 50 exhibits, and there were 5 members, I'd have 5 notebooks. Now, you got to put them into evidence and have them admitted, but they all had their notebooks. Now, today, sometimes it's digital. We put them up on the screen. I mean, it's different depending on the agency. Some are not very sophisticated. It depends on the agency. So you want to make sure you have copies for all board members. You don't want to be the lawyer who's is talking to a witness and the decision makers don't know what you're looking at. So this is a big deal to figure out how you're going to have enough copies for the witness, and the court reporter gets 1, the opposing counsel gets 1, you need 1, and every one of the decision makers needs 1. You need also, what about that lawyer advising the agency? Figure out the number of copies and make sure that you can distribute those. A lot of times there's not issues about admissibility, and you look like you're prepared and you know what you're doing when you hand out the exhibits. Now, you should not do that unless they're admitted in there, unless everybody goes, I don't care, just hand them out. But You want to have those exhibits. Another issue to deal with is whether this hearing is going to be recorded by a court reporter or a tape recorder. The agencies don't have a lot of money, and most of them have a tape recorder, and it's terrible. You can imagine, we said 20 years ago that the court reporters would be gone with digital. Not happening. Might be in 10 more years. But it's hard if the witnesses don't talk up, if the members of the board don't talk up, if the lawyers don't talk up, it's horrendous. And remember, your appeal is going to be from that transcript. So, I don't recall the last time I didn't hire a court reporter. Let me tell you about how you hire court reporters. Court reporters are paid two types of fees. They're paid an attendance fee. Around in South, it's varied in the larger areas, but there's somewhere between $15 and $30 an hour to sit there and to take down the transcription. And now we can even do it in real time. I mean, one of the cases I tried, we actually, because it was lots of money and all that, we saw real-time transcripts from the witnesses. That's a rarity around here because that's very expensive. But in today's world, you pay the court reporter to sit there and take it, and then mostly there's 99% women, and they're becoming less and less, they get paid an original fee per page. That might be $250 to $350 a page, and then they're paid for each copy. It might be anywhere from 50 cents to $1. So what you do, the cheap way to do this is to hire the court reporter, pay her for an attendance fee. If the appeal is never taken, all you've done is pay her for attendance fee. If you have the transcript, then you have a professional that's taken it down. My advice is if you're dealing with somebody's license, get a court reporter. All right? No question about it. I've seen what's happened with the tape recorders, and it's not a good one. You got to find somebody to listen to it, type it up, and it's easier to pay that court reporter who's a professional to take it down. All right, one thing else in the hearing is if the agency doesn't do it, it depends on the quality of the representation of the lawyers involved. But I always establish the agency file at the beginning. By that I mean mark the complaint as an exhibit. Mark what the answer was to the complaint. If there are other things that were done where they're in the file that are part of the agency record, make that an exhibit. You might make the whole file an exhibit, but make sure that you've got the agency file in the record. A lot of people made mistakes thinking, well, it was in the file, it went to circuit court. You have the responsibility in defending your client to make the record, because that's all you got is the record. So you need to get that in the evidence. Keep an exhibit list. Prepare an exhibit list before the hearing. I've done this for 35 years. Actually, you're 2 years off. It's 40. I'll be 41st year this year. Oh. But I've done this for 40 years when I was 24. I make an exhibit list of everything that's going to go in. You don't have to give them your cross-examination exhibits, but what we call our exhibits in chief, and you also get big points with the agency. You come in, you give them your notebook, here's your 50 exhibits, here's my exhibit list. You give them an exhibit list, you give one to the court reporter, and I give it to the opposing counsel. I mean, this is not a big game. If you've disclosed it to them ahead of time, and they should disclose you, you get this exhibit list, and you can check it off as it goes in. Now, you don't have to give the exhibit list to anybody. The court reporter can create it, but it's a way to keep you on task. And we create lines, offered, refused, admitted. That's what the old things, you create your exhibit list. Exhibit 1, describe what it is. And do any of you know what Bates numbers are? You ever heard of that term before? It used to be, you're probably too young to remember, but we used to go into the grocery stores and they'd put the prices on with a little device, the numbers would roll over. That was a Bates number, okay? It would be $2.99, and you pushed it, and then you take 9 to 8, you'd hit it. Well, the Bates number was a way to mark those numbers on. Now we can do it electronically. We can do it through copy machines and all that, and Bates is kind of like aluminum. It just has stayed with it. But I don't produce anything unless it's Bates number. It has a number on every page. So I know what I put in, and it's also very important in marking these exhibits that you have, if you have a 50-page document, well, then you can say it's page 9 of Exhibit 12, okay, because it's paginated. But if it's not paginated, because you'll need it for the record and you'll need it for the witness. So look at your exhibits, you spend some time, And boards appreciate that you're prepared. They're there on their own time. And the better prepared you are, the more favorable impression. They may not like your client, but your next referral might be somebody on that board and said, we didn't like her client, but she did a really good job, and I'm going to send this doctor to this person. I think she did a nice job, and we all liked her. That's how you get business in this area. So being professional, being prepared, having your exhibit list, you're creating your own professional view. All right, let's continue on. All right, we're on to continue to ask for the late filed exhibit. I gave you the example of the email, came up, it was a doctor, hey, look, there was an email, I was out, and they said I didn't come to see the patient, but you know what? I got an email from my wife and my child was sick. Well, let's see the email. And then you say, all right, we're going to reserve 51 and bring the email. All right, let me go back to closing statements. And basically the way it works is in the agency, the agency goes first to put their case on because they've got the burden of proof. The licensee goes second. Then there's rebuttal, and then there's closing arguments. Now very few closing arguments are done at the administrative level, and here's why. Most of the time, the hearing takes longer than it was supposed to. They've got another hearing, they've got another deal, and they're tired of hearings. All right, but you should be prepared one. Oftentimes, what we suggest is we'll do it in a written brief, and they like that. And it's probably best. But sometimes, if you don't have a lot of money, your client can't afford to pay you a brief, then you're going to have to make your closing argument. But that's the strategy of it. That's why the opening is always important. You may not ever get to a close because you might hear some lawyer go, put it in a brief, we got to get on to the next contested hearing. So you may never get your close. You might get a brief that has to be submitted. And oftentimes there'll be an opening, a close, there'll be a simultaneous. Does it run from when we get the transcript? We deal with all that in submitting the briefs. Then you're going to have to submit findings and conclusions after the hearing. And you have to submit the findings to preserve your record on appeal. So now you take the ones that you had before. Evidence always changes. You'll be able to update that with what happened regarding the hearing, and you'll be able to submit these, and you'll be able to protect yourself on appeal. Now remember, it's the findings to support your position, not what the agency said, okay? You're protecting your client. So you've got to protect your client as to what your position is, as to a statutory interpretation. It might have been A versus B, and your version is A you want in the record. You better say that the evidence was what A said, okay? So this is protecting your client. You're not doing it for the administrative agency. That's the job of that lawyer that's up there advising them. Your job is to prepare for your hearings. So you've got to do that. Rehearing, in only one or two agencies, one of them is the South Dakota Public Utilities Commission. Is there a rehearing that's authorized where it says we'll render a written decision and you can file a rehearing to say we screwed up, we missed something? Other than that one agency, I'm not aware of any other that has a rehearing. Settlement. You can always try to settle in these licensing cases through that consent order. You can settle up to the Supreme Court, renders its decision. I remember as a young lawyer going, gee, you mean I can settle this in the Supreme Court? Yes, you can settle this to the last day of the Supreme Court renders a decision. You can settle it after the hearing. If it didn't go well, or maybe it went well, and then you can suggest a consent order and not having to write briefs and not having to have an appeal. Never take the settlement off the record. And sometimes your client won't want to do that. There are very particular things that if you're in the healthcare area, that you need to know that an adverse finding could affect their license, and you need to know that, where some of these adverse findings could be. So sometimes settlement is the best thing that could happen to your client. We may be paying a fine. Other times, we end up in court. Your appeal is 30 days from when the notice of entry of the decision was made, okay? And if you don't appeal within 30 days, you're done. In the law, I would say that there's two things you can't fix as a lawyer. You can't fix the statute of limitations, and you can't fix jurisdiction. About anything else you can fix through negotiation, court orders, or what, but you can't fix jurisdiction. If you don't file within 30 days, you're done. And that's filed with the clerk of courts, and you have to follow what it tells you what to do, but you're done. There's no, and I also defend lawyers. There's not really a good defense for that one, that you didn't file and you've committed malpractice. So so that's not a lot of time, okay? And sometimes there's a situation where, the transcript is later than maybe the decision. You don't have the transcript, always file the notice of appeal. You can always dismiss it. This is what gets lawyers out of bed at night, okay? You can always file the notice of appeal and dismiss it if for some reason your client doesn't want to go through it. But if we've done everything we're supposed to do, we've told our client ahead of time, we've mapped it all out, and we've thought of our strategy, we know what we're going to go to circuit court, we know what our appeal is going to be, and we're going to have talked to them. And if you've done your job, the briefing should not be as difficult because you did all your work ahead of time. Okay, now let's turn to miscellaneous matters. Rulemaking. I'm not going to spend much time on this, but each agency, as I said, has the ability to enact regulations, and you can follow that. There's a process that goes through, and as a citizen, you can initiate a proposed rule. There's a process through that. Most agencies in their regulations allow a petition for a rule. It's got to be noticed. There's a public hearing. It's not like a contested case. People get up and tell whatever they want to say. There's no cross-examination. The agency then can either reject it, write it, draft something else. It's got to go through the government for budgetary stuff and other things. But there's a process, and sometimes these rules affect an industry or a business more than any decision because the regulations apply to everybody. A contested case hearing is only the ruling for the licensee. And so it's very important to understand the difference here. And sometimes you can help your clients by understanding the rulemaking. Like all this EPA stuff that's going on and pollution control, all that, that's coming out of rulemaking procedures in the federal system. They're coming out saying the agencies have gone beyond their statutory authority. Those are all coming out of rulemaking procedures that allow those rules to be appealed through the system. So it's very important in this area to understand it. And there's the rules not adopted the way they're supposed to be are not enforceable. That's why don't assume the rule was enacted correctly. If you're really doing your job, you're going back and seeing was it enacted correctly. And then the declaratory rulings we talked about, that's another thing where you go to the agency and you ask them to give you a ruling. Sort of like the Attorney General's opinion I talked about. But here's the strategy on the declaratory ruling. What you do is posit the facts to the agency and let them rule. And there is a right to appeal through the circuit court the way up, and sometimes you don't know what they're going to do. But if you go for a declaratory ruling, you'd like to know either there's an ambiguity that you want reconciled, or you think you're going to get a favorable ruling. And I want to talk about communications to the agencies because this happens a lot with people. And I will predict that if you are in private practice, you'll be dealing a lot more with administrative law than you think because it's so pervasive. But sometimes you just say, well, call up the agency, okay? Let's find out what they think. And, it's cheap. You talk to some person, and that person tells you this answer. And this happens in the revenue area a lot. And, for 4 years, they did nothing, and then all of a sudden an auditor shows up and says, you owe the tax for this. And you go, well, I called this person 4 years ago. They told me to do it this way. And this happens. Now, there's a statute in the Department of Regulation that says unless you have written advice, you can't rely on it. But that's the Department of Revenue because of that problem. But there's a danger in relying on people in the agencies. I do that. I have people do it to get what they think. But it isn't necessarily binding. And maybe your client, as long as you've explained it to your client, look, this isn't binding. This is what we found out. And sometimes that's all clients want. And maybe you don't know the answer, a statutory interpretation. So you're either going to send them an informal letter, which probably won't be binding on anybody, or you go to a declaratory ruling it's binding and it's appealable. So it's a strategy that's out there, depending on what your issue is. Okay, let's go to the appeal to circuit court. All right, we talked about you got the transcript, you got 30 days to appeal. All right, and I just put this out for a tax case, you've got to file a bond as for the amount of tax due if you lose, and it's jurisdictional. And if you don't file the bond, you're screwed. So don't miss this one. A couple lawyers did do this where they didn't file the jurisdictional ask. The bond on a tax case, it's jurisdictional. The stay we talked about, whether you're going to go in that 10 days and try to stop that decision for that licensee that you're representing, that doctor or that dentist because they need the profession. The venue of the appeal. Remember, venue is where the place of the appeal is. This has changed. In South Dakota, if you are a real person, you can appeal to the circuit court where you live. If you're a non-resident corporation and have a principal office in the state, you can go where your office is, and the fallback is always Pierre for everything else. So the judges in Pierre, Hughes County, get a lot of appeals, but it is different. So if you represented a dentist or a doctor from Sioux Falls, you can appeal to the circuit court physically from Sioux Falls. When is your brief due? There's a statute that sets forth when the brief is due, and it runs from the transcript. It's a 30, 30, 10, or 15. I always get a scheduling order. I pick up the agency lawyer who's going to handle the appeal, and we agree on what it's going to be. This is one of those things you pick up the phone and you see you've got a vacation, or your spouse or boyfriend or girlfriend, you're going to take a trip after 30 days. Get on the phone, get it scheduled ahead of time. In this state, nobody's going to turn you down. I need 45 days instead of 30, okay, because I'm taking a vacation. My family or my spouse or my girlfriend or boy, you'll get it every time. But do it ahead of time. Do not wait for the last week when you can't get it done or you realize you had a vacation. This is upfront scheduling. Statement of issues, you have to set forth what you think the issues are in certain cases, so people can write their briefs. Just because you don't put it in the statement of issues doesn't mean you can't brief it. Okay, let's see. Now we're going to go to the transcript. We talked about that. If we followed the advice, you've got a transcript. If you've decided to appeal, you will then pay for the transcript. And you've already got it. Your record to be assembled. The agency is responsible for putting the record together of the proceeding and send it to circuit court. The record are the exhibits, the transcripts, everything that's in that contested case hearing. Oral argument, the statutes allow the circuit court judge to hear oral argument. Most of them do want to hear it, unless it's just something they feel it's a strict question of law. Something that the circuit court can do, and when Justice Zinner was on the circuit court in here, he was famous for doing this. He would look at some record and say, you know what, I think the agency didn't look at this record, and so I'm going to remand it back to the agency to look at this particular issue. And that puts you in quite a dilemma, because if it's remanded back, do you file the notice of appeal and say, there are 3 issues, and I'm going to remand issue 1 back to the agency because I don't think they considered this. Well, what about issues A and B that he's affirmed on? And it's a very big dilemma. The only way I figured out is you file your notice of appeal to the Supreme Court and ask them to stay that until the other shows up. So the very cagey circuit judges will do this, and sometimes we also ask if the agency, completely missed something to go back, but they can remand it back. Here's a big scope of review issue. The circuit court is a whistle stop, despite what that statute says. By that I mean the circuit court's decision is given no deference at the Supreme Court level. I'll tell you a personal story. It was a former circuit court judge in Pierre. He was the Supreme, and he used to call and he said, Tommy, we need to draft a statute. I just spent 30 pages writing this PUC decision, and it means nothing. And so we drafted a statute that would say that the Supreme Court had to give deference. They don't. You're a pure whistle stop. So in your strategy, the Supreme Court is going to sit just like the circuit court. So when you're looking at the economics of your case, if you really have a good de novo issue and you've lost it at the circuit court level, your brief should not be much different at the Supreme Court level. So in the economic world, the marginal cost of doing that appeal, if you've done everything you're supposed to do, shouldn't be that much, because you've done all your work and the review is the same. And if you've analyzed the issue correctly, you know it's de novo, the circuit court doesn't mean anything, and it's going to be at the Supreme Court level. At the same scope of review, you get 5 judges versus 1. Seems simple, but when someone tells you that, but it's not something that you really figure out. But remember, this is how it works. It'll save you, and this goes back to the preparation ahead of time and your whole strategy for the case. Okay? We're going to do quickly the workers' comp area because it's unique. It's part under the Department of Labor. It's, as you remember from your tort, workers' comp is an exclusive remedy for work-related injuries. The only exception is when an injury is the result of an intentional tort, and it's nearly impossible to prove. To be compensable, the injury must rise out of the course of the employment, and written notice of injury must be provided to the employer within 3 business days unless the employer had actual knowledge. And the work incident must be a major contributing cause of the disability, impairment, or need. Okay, that's the workers' comp claimant. The benefits they're determined at 2/3 of the employee's average weekly wage, subject to a minimum and maximum established by the Department of Labor. The benefits include reasonable medical expenses for life, so you don't in workers' comp. And remember what the benefit of workers' comp is? The employer is not in the tort area. This is a completely separate area. They have temporary total, temporary partial, permanent, rehab, permanent total, these all benefits. And this is not an area for the neophyte. These are very specific, and if you have one of these in your first year of practice, go talk to if you're on the claimant side, talk to the claimant lawyers and do this, or the workers' comp. This is a very specialized area. There are defenses, misconduct, intoxication, falsification. Let's go on. Petition for hearing must be filed with the Department of Labor within 2 years of the date of denial of the claim. The rules of civil procedure apply. The Department of Labor has its own hearing examiners. They're contested case hearings. The appeals are governed the same. You get lawyers' fees here, but they're limited. They're like 25%. And all attorneys' fees need to be paid to approved by the Department of Labor. So these are common claims, but the first one, talk to somebody, because I've never done one of these, but we have 3 to 4 lawyers that do these in our file, in our firm, and they're very technical. And there's this group of people out there, the claimants, the group that are the insured employers. So if you have one of these, you can read the statutes, but the calculation of the benefits and some of the nuances are very, very particular. And you, representing a claimant, don't want to leave money on the table for your claimant because your claimant's not going to have another remedy. And if you're the insurer, they'll contact somebody. You don't worry about that. But the claimants people are the ones you worry about. Okay, now we're going to talk about our project and what we're going to do here. The first writing project is going to be drafting a set of findings and conclusions. And here are some tips. And the more you do this, the better off it is. But draft ultimate facts, not evidentiary facts. Now, does anybody know what the difference is? What's the difference between an evidentiary fact and an ultimate fact? Let's take an example. We don't write down witness A, let's take our licensing. Witness A said that Dr. Jones said this or that. Now, it might be a rare thing. You would be something like that Dr. Jones didn't come to the office. You wouldn't say witness A testified. You said Dr. Jones was called for a patient and didn't come to the office. That's an ultimate fact. Who said it, how it's presented, is an evidentiary fact. Now that's easy to say. It's not easy always to draft. But that's what you're searching for, is ultimate facts. So you do not have to write down every fact that came out in support of your case. They're broader, and you'll see in some of the ones I gave you. Draft the findings and conclusions to meet the statutory requirements. You're going to have been charged with a regulation or with a statutory violation. You're going to have to address in the findings and the conclusions those statutory or regulatory guidelines. You must address the burden of proof. We've talked about now, in most cases, it's going to be preponderance, clear and convincing if it's going to be a license revocation. So those are going to be your burdens of proof. Do not forget to include credibility findings. Now, this is something that's not, that most people who haven't done this before do not do, but I'm going to tell you about it. Remember that the finder of fact, the agency, can decide if A is telling the truth or B is telling the truth. And one good drafting thing is to say, if it supports you, that, I find witness A to be credible because she was there at the time that the incident occurred, that the patient complained about it, or something like that. That's credibility. And those are not substituted by courts. So if you have a case that's factually driven, and you have good facts, and you have good witnesses, making the credibility determinations are critical, because that is going to be a huge deal on appeal. So you've got one key witness, and it's believable. If you write a finding that, dental assistant A testified that Dr. Jones called and came to the patient, and as soon as he came from his sick child or something like that, that she can, that was credible, and that she was credible because she wasn't getting paid to do anything other than to work. She was there, she saw the email to the spouse. Those kinds of things are critical because the courts will not substitute their judgment for that on appeal. Do not forget about negative findings. A negative finding is something that was failed to be done. You failed to carry the burden of proof. On a license revocation, the agency failed to prove by a convincing evidence that the license ought to be taken. That's a negative finding. Most of the time we're trying to get our position there. Never forget about the negative finding. Okay, that if you said, or another, what comes into the agency presented no evidence on this issue. That's a negative finding. So you have positive findings, how facts come out, negative findings as a failure of proof or failure to adduce any sort of proof. So it's a failure of proof or a failure to adduce proof. Those are some other things. This is, and you'll see this in the sample one, so I drafted so you can watch it. It's a catch-all. Sometimes the difference between a conclusion of law and a finding of fact is not easy to tell. And I can tell you after 40 years, sometimes I can't tell the difference. And so what I put at the bottom, and you'll see in yours, a catch-all. If I've designated this wrongly as a finding of fact, and it should have been a conclusion of law, then consider it as a conclusion of law. And if I've designated this a conclusion of law and it should have been a finding of fact, then consider it. It's a catch-all. It's a really good drafting thing to put in the bottom of both of yours. And then make sure that in your conclusions of law, you make a finding that the statutory requirements were or were not met by the appropriate burden of proof. You see these negative findings? So if you're representing somebody and you think that the agency did not prove the violation they allege, your finding is going to be that the evidence failed by a preponderance of the evidence or revocation to prove any statutory violation of statute X blank or regulation, whatever it said in that notice of hearing that you got. And then the last thing, always include a decision. Complaint dismissed. That's what you're normally, if you're representing a licensee, complaint dismissed. That's what you're going to say. That's the decision, because you're going to have your appeal is to the findings of fact and the decision of the agency. Now, at the circuit court level, the circuit court is bound to accept, reject, or modify the findings and conclusion of the decision of the decision maker, the agency. Sometimes I've had just judges they'll walk in and say, the agency was right. It's a one-page order that says, I affirm the findings of fact, conclusion of law, and the decision of the agency, and then you're on to the appeal to the Supreme Court. Sometimes the circuit court may go, I reject this, and I modify it to this, or something like that. And that's what the circuit court needs to do. So I've completed the outline, given you some guidelines. Now, my understanding is there's an unemployment case, an unemployment compensation case with a set of findings and also the fact pattern. I decided to make sure you could see the fact pattern to see how he drafted those. And then you'll see the fact pattern for the realtor. And this is a real case. It's a mixture of real stuff. This is not a hypothetical. It's a real case that's been involving different issues. And it's going to be interesting for you because you're going to represent a realtor before the South Dakota Realtor Board. And so We're going to get you involved in preparing a draft set of findings before you go to the agency. So this is what's going to be in your laptop. It's going to be your draft set. It's going to be your checklist, not to submit, but this is what you're going to do, what you're going to submit based upon the fact pattern that you've been given. Okay? So is there any questions? No questions?
I have one question. Sometimes agencies will give you the option of having the agency review it or take it to circuit court. Like the Department of Labor in an unemployment case will say.
Go to the secretary. Is it appeal to the secretary or like the revenue department?
Do you find you should just go to the circuit court level?
Well, sometimes it depends on the statutory framework, because in certain areas, say, for example, the revenue department, the decision can only be made by the secretary. So there's an automatic review. Like in the revenue, you go through a contested case hearing, you might do the administrative hearing, examiner will do that. The secretary must affirm, reject, or put it. It depends on what, I mean, in some agencies, you can go without going through that. It depends on the nature of the case. I would say most time, the secretary or the highest person is not going to change it. So if you have the option, and the only way you know that is to look at the statutes, I would go to circuit court. But if you've done your homework and figured out what your issue is on appeal, it all goes back to that critical phase I was talking. If you've done that and go, it's de novo, I don't care. Because, for example, constitutional issues cannot be decided by an agency. My partner was up arguing a case today on a constitutional commerce question, a tax case. The agency doesn't have the authority to talk about that. So only the circuit court can deal with Why go to the secretary? He or she doesn't have the authority to deal with it anyway. So very rarely, I mean, if you have to appeal, if you have to go that way, oftentimes you do. If you have an option, I would go to circuit court if you've done your homework and know where you're going.
Okay, contrary to the syllabus, we meet in here tomorrow at 4. Thank you for pointing that out. And everyone, please come prepared with a couple of questions for Tom via our conference call. Your assignment should come out on Twin at 6 o'clock in 10 minutes, I hope. If it doesn't for some reason, I'll be watching, but email me. So you can always get a hold of me on my work email at any time. If something doesn't work, things